idiom watem na Obani accent so you can have they don't know that that's what the court expect for.
Hello. So Happy New Year to us all, and you're all welcome to today's episode of The Lawyer's Diary. Today's topic is quite a technical one, but we'll try as much as possible to make it very understanding for everyone to understand. So the topic is the Guan Parliamentary election crisis, Guan next. And our guest speaker is Chris Nyinevi. Chris is a personal friend, and I've known Chris for over 10 years now. He's currently a lecturer at the Faculty of Law, KNUST, and he does well in constitutional law, legal writing, public international law, and also the African Union law. He has published various journals and book chapters on the Supreme Court jurisprudence. He loves writing, he loves these kind of topics, he loves technical things, he loves constitutional law. And he has since 2014 been a member of the Ghana Bar, and I'm sure he's registered with the Ashanti Bar. And he's currently doing his doctorate at the Mona University in Australia. So when this whole matter came, I reached out to Chris, I call him Prof, and he said he was willing and able to get us, but it's been one thing after the other, and successfully and hopefully we've had him today. So, Prof, welcome to The Lawyer's Diary.
Thank you, Onesmus. Yeah, I have unmuted myself. Is it clear?
Yeah, it's clear. We can hear you.
Okay, good. Okay, good. Thank you for bringing me the program. I'm happy to be here.
Sure. So one of the key things about this program is that we try to demystify the languages. We try to make it as easy as ABC so people can really understand. So, Prof, this is just by way of notice to you.
Right.
And then before we go on, today's program is sponsored by Dennis Law. Dennis Law is a global digital platform where they do research, they do legal researches, case laws, and other stuff. So if you're a lawyer, you're a law firm, and you want a digital platform to subscribe to, I entreat you to log on to Dennis Law, reach out to them. They are on all social media platforms, so they can come do the installation and probably even do a bit of a demonstration for you to know before you decide. So in the course of the program, we'll have one member of Dennis Law come to talk to us about what Dennis Law is, what they do. And if keenly followed the current Supreme Court matter, Dennis Law is one of the people who brings us daily nuggets about whatever is happening at the Supreme Court. So, Prof, now let's zoom straight into action. Our topic for discussion is the Guan Parliamentary crisis. We all know that before the December 7th election, the EC sends us a notice instructing that the people of Guan can only vote in the presidential elections. So give us a bit of background. What happened? Because I know as a lawyer that every person of sound mind, if you look at the Constitutional Article 42, says that every person of sound mind in any public election has a right to vote. So what happened?
Right, so a series of events culminated in that decision by the EC to prevent the people of Guan district from voting in the parliamentary elections. And if you want to list them, I think you probably would find about 9 separate incidents that led to this whole situation. So I'll try and go through them quickly, but it all started with the creation of new regions by the president in 2018. So we all know that when President Kufuor came to office, he decided to consider petitions from various parts of the country that had for many years asked government to make their areas new regions. So one of those petitions came from the people who now constitutes the OT region. And obviously, we also know that there were some petitions from other parts of the country. So the president set up the Justice Brobe Commission to look into whether there was a substantial demand for creation of new regions. And the commission recommended that, yes, there was. So in December 2018, the Electoral Commission then conducted a referendum to determine whether those areas that had presented petitions where the people in those areas were willing to break away to form their own regions. And the referendum was done. So based on the results of the referendum, 6 new regions were created, and what is now OT region is one of them. Now, so in February 2019, the president then decides to complete the creation of the OT region by passing or executing CI 112, which is the OT region instrument. It's a constitutional instrument. So another instrument, the president places 4 communities, Central Kofi, Akpafu, Likpe, and Lolobi traditional areas in OT region. So these 4 communities are known as, have become known as the SAL communities. So Central Kofi, Akpafu, Likpe, and Lolobi. Now, prior to this, the SAL communities were part of Hohoi municipality in the Volta region, and they were also part of Hohoi constituency. So these traditional areas claimed that they did not support a petition for the creation of OT region and did not participate in the referendum. So they didn't understand why the president had placed them in the new OT region. So there were some legal challenges about this, which I would, one of which I will touch on subsequently. But then what happens is that, so the SAL communities are now in OT region. And normally, when that happened, because they had been separated from Hohoi municipality and sent into a new region, there should have been a decision immediately whether to add them to a new district in that new region or to create their own district for them. And under the Local Governance Act, the president is the person who's supposed to do that. But that did not happen immediately. So what happened instead was that the Electoral Commission then decides that it was going to organize the 2019 District Assembly elections. And because the people of SAL, those communities had to vote in the District Assembly elections, the Electoral Commission made what is known as the District Electoral Areas and Designations of Units Regulations 2019, CI 119. And on that CI 119 placed the SAL communities, Santon Kofi, Akpafu, Likpe, and Lolobi, under Jasekan district for the purposes of that election. So it appears that when the SAL communities were moved from Hohoi municipality into OT region, they were placed under Jasekan district for purposes of local government, at least with regards to the 2019 District Assembly elections. Then that decision by the EC to place them was challenged. They went to court over it, and I'm not sure what the status of that case is. But what happened was that subsequently, because the SAL communities were previously under Hohoi constituency, and they had now been moved into a new region, we weren't sure what constituency they were part of, because technically CI 95, which is the law that put them under Hohoe constituency, was still in force. So we needed to determine that. And there was a case in the Supreme Court, that's the Jache versus Ametepe, which decided, in which the Supreme Court decided in June 2020, that because of the creation of the new regions, which has resulted in the South communities being placed in Oti region, the EC had to amend CI 95 to realign the boundaries of Hohoe constituency so that the South communities will no longer be part of Hohoe constituency. In that case, the plaintiffs had argued that the president had no power to add the South communities to Oti region because the constitution in Article 47.2 prohibits the situation where constituencies will straddle the regional boundaries. So the president should have had regard to CI 95 and by extension Article 47.2 and should not have placed those communities in the Oti region. But the court disagreed and said that rather, when new regions are created and it affects boundaries of constituencies, it is the constituency boundaries that rather have to be realigned with the new regional boundaries. So the court then orders the EC to amend CI 95 to realign the boundaries of constituencies that had been affected, particularly the Hohoe constituency, under which the South communities were previously voting. So after the decision of the Supreme Court in that case, the EC then in July 2020 makes a new constitutional instrument, that's CI 128, Representation of the People's Parliamentary Constituencies Instrument. And in that instrument, the EC places the South communities under Buem constituency in Oti region. And just to be clear, Buem constituency is the same as Jasekan district. So the whole of Jasekan district constitutes Buem constituency. So earlier on, the EC had placed them under Jasekan district for purposes of local government elections. And then in CI 128, it now formally removes them from Hohoe constituency and places them under Buem constituency for the purposes of parliamentary representation. Just when the EC finished that process of placing the South communities under Buem in Oti region, the government now decides to do what they should have done earlier on, either by formally adding the South communities to a district in Oti region or creating a new district for them. So when the EC finished that process of adding them to Buem constituency, the government now decides that they want to create a new district, a separate district for the South communities. So the government lays an instrument in Parliament, I think in October. The instrument comes into force in November, and then they create Guan district. So the South communities, that is Santo Kofi, Apafu, Likwe, and Olobi, now become Guan district, separate from Jasekan district, which they had been associated with earlier on. So with the creation of Guan district, the EC then decides that they need to create a new constituency for the people of Guan. And this decision to create a new constituency is informed by a certain practice that the EC has had over the years. So when you look at Article 242B of the Constitution, it says that the composition of a district assembly shall comprise members of parliament who fall within the area of authority of the district assembly. And the EC has, over the years, interpreted this constitutional provision to mean that just as constituency boundaries should not straddle regions, you shouldn't have a constituency that covers more than one district, with the result that you would have one member of parliament having to be an ex-officio member of more than one district assembly. So in that sense, the EC has interpreted Article 242B to mean that whenever new district assemblies are created, it has to realign boundaries of constituencies to ensure that you don't have more than one, a constituency covering more than one district. So because now the government had created Guan district, which falls under Buem constituency, and you are going to have Buem constituency comprising Jasekan district and Guan district. The EC decided that it needed to create a Guan constituency so that Buem, the member of parliament for Buem, would have responsibility for only one district, which is Jasekan district, and then the new whoever is elected MP for Guan constituency would also have responsibility for only one district, or be the ex officio member of only one district assembly, which will be the Guan district. So that's what the EC decides to do. But then the December 2020 elections was fast approaching. So Parliament needed to go on recess because members of Parliament are also interested in the election, and they have to campaign, and those of them who are contesting elections to come back to Parliament need to campaign, etc. So Parliament needed to go on recess before the December 7th general election. So Parliament goes on recess, and so there is not enough time for the EC to lay a constitutional instrument in Parliament to create Guan constituency, because the constitutional requirement is that, and Article 11 is that for a constitutional instrument to become law, it has to be laid in Parliament, published in the Gazette on the day it is laid, and stay in Parliament for 21 certain days. And if Parliament does not annul it, then it comes into effect on the after 21 certain days. So there was not enough time to do that, to satisfy the constitutional requirement. So the EC could not create Guan constituency before the December 7th elections. So that is what culminated in the directive the EC issued a day before the election, on the eve of the election, that is on 6th December, directing the people of Guan district that they could only vote in the presidential election and not in the parliamentary election, because the EC had in mind that they were going to create for them their own parliamentary constituency so that they could elect their own member of parliament. But that didn't happen. So that is why they couldn't vote in the December 7th elections. So it was because of this series of events. But wow, the main cause of it was the creation of the new region and how the whole process was handled, thereafter.
Yes, Chris, so that's a very good and excellent summary. But I mean, listening to you, it appears that it therefore becomes an administrative problem of the Electoral Commission and the members of Parliament. How does that translate into denying people of their constitutional rights? Because if the bill needed to be in Parliament, the whole idea about this whole formation of Guan wasn't just it wasn't just something that came up on the eve of the elections. If they really needed to do that, they ought to have done that months before. So yes, why would we allow administrative errors to deny people of their constitutional duties?
Right. I mean, so it's unfortunate what has happened. But yeah, that is the situation we find ourselves in. So given the timelines we have for election, etc., it should have been obvious to the Electoral Commission and all the other stakeholders that this thing could deny people the right to vote. And so whatever administrative processes needed to be done should have been done expeditiously, etc. But I mean, you also understand or know how things work in our country. Sometimes, people are a little sluggish in trying to perform their functions. So these things do happen, and it's unfortunate, but it's not a fault of the people there either. So now we have a situation where they were unable to vote for a member of parliament in the December 7th election. So yeah. So I mean,
now let me take you back to the chronology. In the chronology, yes. You said the people of SAR earlier on indicated that they did not participate in the referendum.
Yes.
Yes. So was that a requirement for the referendum? And if indeed the people of SAR did not participate, what was the ground for which this whole process, because the people for which we are creating the constituency doesn't participate? On what constitutional, legal, or administrative right does the EC or any other person have to proceed, even though the people did not participate?
Right. So, well, that's a claim that has been made, and I should be careful to say that I'm not in the position to verify it. But that's some of the media reports I've seen, because what happened was that some chiefs of the areas that now constitute OT region presented a petition to the president for the creation of a new region. And what the people, what the media reports I have read, and based on the subsequent, actions of the SAR communities, I mean, challenging the creation of the new region in court, etc., etc. So it probably confirms the idea that, or the report that they did not support the creation of the new region. So the argument is that they were not parties to the petition that was presented to the president for the creation of a new region, and because of that, majority or an overwhelming majority of the people in those communities did not vote in the referendum asking, demanding the creation of a new region. And so as far as they are concerned, sort of, they do not consider themselves to be part of that new region. I mean, that's sort of the argument. But legally, I think that matter has been laid to rest, because the president appointed a commission, the Justice Bobo Commission, and it went around the country soliciting the views of those areas where they were asking for new regions. The report of the Bobo Commission itself was challenged in the Supreme Court. The Supreme Court, I don't think it was a report. I think rather it was the holding of the referendum in particular areas of the country, instead of in all, in the regions where in the whole region where the carve out was going to be done. Or so I think that the argument before the referendum was that if a part of the region was going to be carved out, the people of the whole region should have a say in that. But I mean, that was challenging the Supreme Court, and that didn't work out. So eventually the referendum was held, and the SAR communities were designated as part of the areas where the referendum was to be held. So the thing is, I'm not sure if it's really material, because it's a majority vote. So if your area is designated to be part of a new region, you can vote against it, or you may decide not to vote at all. But if the requisite majority is attained, the decision may bind you, right? So I think probably the proper legal question to ask is whether in the creation of a new region, the communities which participate in the referendum have to be communities that actually supported the petition before they can be included in the referendum. I think probably that's the question to ask. Yeah, but I think we are probably past this stage now, and so that's the situation.
So, Prof, keenly following, the whole discussion of Guan, yes. One of the options were that we conduct elections even after the 7th of December, and it should be before the inauguration of the 8th Parliament. That was the early January.
Yeah.
So, the question now is that what is the constitutional implication of not having the elections before the inauguration of the 8th Parliament?
Right. So the inability of the people of Guan to vote in the election has very serious constitutional implications. So one, we are looking at a breach of the right to vote, I mean, which you rightly mentioned in Article 42. So every Ghanaian of 18 years of sound mind is entitled to be registered and allowed to vote in all public elections and referendums. And so when people have duly registered and they are now prevented from voting due to the administrative errors or inertia of the body responsible for conducting the election, it would seem obvious that that is a denial of the right to vote, a denial of the right to participate in the political process. So that's one. Now, the second thing is that every part of the country is entitled to be represented in parliament because it's a democracy we are running, and democracy is based on representation. And you know, so not only must the people vote for a president, they are also, not only are they entitled to vote for a president, they're also entitled to have a member of parliament represent them in the body that makes laws for the entire country. So if from the first day parliament sits, the people do not have a representative to represent their interest in the foremost body that makes laws for the entire country, then that seems to be a denial of their democratic rights of participation or representation. And so that to me is a serious thing. And it was important that they could vote before 7 January, because on the first day Parliament meets, a very important constitutional business is transacted. And when you look at Article 95, it says that when there's a vacancy in the office of Parliament, in the office of the Speaker, sorry, Parliament cannot transact any other business until they elect a Speaker. So what it means, therefore, is that the first day Parliament convenes, because there is no Speaker, the first item on the agenda must be the election of the Speaker. The Speaker is elected by a simple majority, but to remove the Speaker, you need 3/4 majority, not even 2/3, 3/4 of majority in Parliament. So that's 75% majority to be able to remove the Speaker. And so if you are not represented on day one and you do not have a say in the election of the Speaker, it's almost impossible for you to remove the Speaker who has been elected for the people to be represented in the future to now have a say in the election of a new Speaker. So we have gone past that now. I mean, the Speaker has been elected, he's in office. Even if in the future, the people of Guan have a member of parliament, it's almost impossible to remove the Speaker for the member of parliament for Guan to be able to participate in the election of a new Speaker. And we know the important constitutional role the Speaker plays in our system. The Speaker is third in line in the succession line to the presidency. So if the president is not unable to perform his functions, the vice president is unable to do so, it falls on the Speaker. So the speakership is a very important constitutional role, not only as the presiding officer of parliament, but also a person who could potentially become acting president. And so it is important that every part of the country has a representation or a say in the election of the Speaker. And the fact that the people of Guan have not been able to, have not had a representation in parliament from day one, and therefore have not been able to have a say in the election of the Speaker, I think is a very grave political injustice. So in my view, that's the reason why they needed to have. We should have considered it a priority to ensure that
they were able to we have explored any legal option to prevent this in a way that probably they could have had elections before the 7th of January. Well, because one of the things that you said was that Parliament did not come back after recess, and we all know during the heat of election, people needed to go campaign. Yes. So we are done with the elections. What prevented us from rectifying our mistakes?
Yes. So there were a number of options. So based on the decision the AC had taken, what it meant was that there were possibly two options. the people of Guan could vote if they got their own constituency, which is Guan constituency, which the EC had proposed to create for them. That's not one. Or if they were retained in Buem constituency, that would also be possible. But both options had, serious legal implications, so which we need to consider. So let me consider, for instance, the first one, which is creating a new constituency. When Parliament, after the election, Parliament resumed its sittings, but then there wasn't sufficient time between the time it resumed sittings and the time in 7th January for there to be 21 sitting days. That is necessary for laying a constitutional instrument in Parliament. So to be able to create a constituency for the people of Guan, the EC would need to lay before Parliament a constitutional instrument. It has to be in Parliament for 21 sitting days to enter into force before the election could be held. And between the time of after Parliament, the time Parliament resumed after elections until 7th January, which is the day of inauguration, there wasn't sufficient time for that 21 constitutional maturation days to be satisfied. So that seemed like an impossible route. The Article 11.7 procedure didn't seem likely. It wasn't likely. It couldn't happen. There was no way you could fulfill it. It was impossible. So then the option of retaining the people of Guan in Buem constituency, in my view, would have been the easiest to do. And that simply meant that you retain the Guan district in Buem, but then you have to rerun the Buem election, because then it means that because a large section of the Buem constituency was prevented from voting, which is the South communities, you now have to organize a new election so that the election will be representative, etc. So that would mean that it would disrupt the election that had been conducted in Buem on 7th December, but at least it is, in my view, a fair price to pay for ensuring that the people of Guan were able to vote for an MP. But the only reason why the EC was not considering that option was because of what I said earlier on. This interpretation that has been given to Article 242B, that constituency boundaries must also align with district assemblies, so that you shouldn't have a constituency that contains more than one district. So that was the only reason why the EC was not considering that option of retaining the Guan district in Buem, because they thought that if they did that, in their view, is a constitutional violation. But I'm not sure about the correctness of that legal argument, because that is just the EC's interpretation. That interpretation has not been endorsed in any Supreme Court decision. And I thought that if it was possible for a case to be brought in the Supreme Court to challenge that practice of the EC, and for the court to have declared that practice of the EC aligning constituency boundaries with district assemblies unconstitutional, then it would have paved the way for the Buem constituency elections to be rerun, because technically the South communities are still part of Buem, because the EC has not amended CI 128 under which it placed them. So that would have been possible if the Supreme Court just declared the EC's practice of realigning constituency boundaries with district assemblies unconstitutional. That would mean that the directive they issued on 6th December is unconstitutional. And so the South communities of Guan district is properly part of Buem. And so Buem election would have to be rerun. And then I think that could have been possible. I mean, you can go to if the Supreme Court wants to expedite the hearing of a matter, it could do so in probably a day or two, give its decision, reserve its reason for a later date, and then order the EC to hold the election. Probably that could have been done if we were serious about it. But that was not done. The only other option, if the South communities were not retained in WIM would have been to find out whether it's still possible to create the Guan constituency without going through the Article 11.7 procedure. And I wrote an article which I published on Ghana Law Hub, which I'm sure some people may have read.
Yeah, I've read that article.
Yeah, so where I made some, if you like, some constitutional gymnastics, you know, and based on some previous decisions of the
I read the various articles you were quoting, and then the interpolations you were the if this then that, if this then that.
Yeah. So I mean, the Supreme Court has given itself a so-called power of ratification, by which it claims that it can rectify provisions of statutes that are inconsistent with the Constitution. And it did that, the court did that in the Pigwe number 3 case, Martin Pigwe versus Attorney General, where Martin Pigwe challenged the constitutionality of the practice where security agencies arrest persons and put them in jail over holidays, during holidays and over weekends, and deny them the right to be brought before a court in 48 hours. In that case, the court said it was unconstitutional. And then the court then proceeded to declare certain provisions of the Holidays Act and the CI 47, the High Court Civil Procedure Rules, and the Labor Act unconstitutional. But instead of the court ordering the Attorney General or Parliament to take steps to amend those provisions of those legislations that offended Article 14, the 48-hour rule, and to bring them into conformity with the Constitution, the court decided itself, under this power of ratification, to rectify those provisions. So the court itself sort of drafted new provisions which it considered consistent with Article 14, and sort of read them into those statutes. So that is an extraordinary power to claim. And under Article 2 of the Constitution, the Constitution gives the Supreme Court the power to make consequential orders and directions when it has made a declaration of unconstitutionality, to enforce its declaration. But curiously, in that Martin Pigwe case, the court did not base itself on Article 2. It rather based itself on some old decision from, I think 1987, 86, I guess, certain Sasu case. I've forgotten the full title. In that case, the Supreme Court then interpreted the Courts Act 1971 and said that there was some inconsistency or gap in it. So it read into it some phrase with leave of the Court of Appeal. I think that the case had to do with the right of appeal from the Court of Appeal to the Supreme Court. So it read that into the statutes. And so the Supreme Court in the Pigwe case used that Sasu case as a precedent to claim the power to rectify statutes. And so I thought that, well, I mean, this is an extraordinary power which should not be exercised because there's a separation of powers. So if there's an issue with an act of parliament, it's inconsistent with the Constitution, you make a declaration, but maybe you will need to redraft portions of it to neatly bring it into conformity to the Constitution. In my view, that should go to Parliament because that's the legislative function. But the court decided to do that. And so if you are, a constitutionalist, you would have concerns about that because that's a work reserved for Parliament. But in the situation in which we find ourselves, I thought that, well, this power of ratification is not one that I would ordinarily endorse. But if we could use it for a good purpose and allow the people of Guan to be able to elect a member of Parliament before December 7th, then why not? So that was my argument in that article. So I thought that, well, if we can use the Article 11.7 procedure, which will require 21 certain days, then let the EC itself or Attorney General or whoever civic-minded citizen go to the Supreme Court and say, look, people of Guan have not voted. It breaches the Constitution. because the AC says that if they retain them under BWIM, that will breach Article 242B. So you have the power to rectify statutes. CI 128, which places the Guan district under BWIM constituency, is inconsistent with Article 242B, if the Supreme Court accepts that interpretation. And then, if it accepts that interpretation, then it should declare those portions of CI 128 that places the South communities under BWIM as inconsistent with the Constitution, and then proceed to rectify CI 128 by designating the South communities as a separate constituency, just like it did by rectifying the Holidays Act, and etc. So that's the argument I was making, that if the Supreme Court did that, then we wouldn't need to go through the Article 11.7 procedure.
But that's
sort of more academic, I think.
Constitutional person, you also say that then the Supreme Court is sidestepping into the work
yes,
of
exactly.
Parliament. Yes,
exactly. That I made the same point. Yeah. In that.
All right.
article.
So, Chris, we'll move to the next segment, but just 5 minutes break. But before then, when we come back, the next question will be that there have been two schools of thoughts. The main question now is that what is preventing Parliament from immediately amending those laws? The other thing is what is also preventing the EC from immediately also running the elections? I know others have quoted Article 47.6, whereby the Electoral Commission cannot just hold elections, but it has to be pending a general or an upcoming election. Because if you look at 47.6, it says that where the boundaries of a constituency established under these articles are altered as a result of a review, the alterations shall come into effect upon the next dissolution of Parliament. And the next dissolution of Parliament will be 2024, when we are having the next elections. So, Chris, we'll come back to that, but let me do a bit of promotion of the Lawyer's Diary page. So I've displayed the Lawyer's Diary's pages, social media platforms on the screen. On Instagram, we are Lawyer's Diary Global. Please follow us and get all the updates on the things that we've already done and the upcoming programs. And also on YouTube, Lawyer's Diary, please subscribe and click on the notification button. We always upload all the videos that we do on the page. So when you go there, subscribe, and then you get to watch all the ones that we've done from commercial law, criminal law, international law, alternate dispute resolution, among others. This year also promises to be an exciting year with a lot of legal stuff coming. There's an upcoming program which is also called Know Your Lawyer. Under this segment, we'll go into the personal lives of your lawyers so you get to know what they do and why they choose a profession in which they are. So, Chris, back to our question. What is preventing the Electoral Commission from immediately rectifying the mistakes? What is preventing Parliament from also rectifying the things that have dragged us into this mess? And then that's Article 47.6 in any way, or is it applicable to this particular instance, or this is a special case?
Right. So now that we have the 8th Parliament inaugurated, I don't think there's any impediment in the way. The only, so the EC can proceed to lay the relevant constitutional instrument in Parliament to amend CI 128 and then proceed to create the Guan constituency. But I think maybe what probably might cause a little bit more delay is the presidential election that we have in the Supreme Court, which is sort of has engaged the attention of the EC in the meantime. And I also think
with that one, very soon we'll be coming again for some bit of clarification just on the electoral petition. So please be informed.
All right. Now, the other thing I suppose that would delay it a bit is that, Parliament is still forming its committees, and to be able to have the relevant instrument laid in Parliament, you need to have in place the subsidiary legislation committee, for now, I think they have only constituted the appointment committee and the business committee and the committee of selection, which is a committee that forms the committees of parliament. So I think these internal processes in parliament may need to be completed, especially the formation of the subsidiary legislation committee, because it's that committee that would scrutinize the instrument that is sent to parliament on behalf of the House and then present a report and make a recommendation as to whether it should be allowed to mature. So I think there's nothing that stops the EC from proceeding to lay the instrument in parliament. But these political and administrative things, internal things in parliament may delay it a bit. And also, like I mentioned, the election petition may also, I'm sure, distract them a bit. So they might want to wait until the election petition is concluded before they present it to parliament. But I don't really know if they have to wait. I mean, they could, as we say, walk and still chew gum. So they could probably do both at the same time, but we'll have to wait and see what happens. Now, concerning your question about Article 47.6, so the Constitution says that the EC can review the boundaries, the constituency boundaries. And the reason is that there are a number of factors that are taken into account in the creation of constituencies. One of them is the population quota. So the Constitution provides that as much as possible, the population in each constituency should be nearly equal as possible to those of other constituencies. So you should have almost like the same number of registered voters or the population in each constituency. So, and then there are other factors like communication routes and regional boundaries, etc. Those are other factors. And traditional areas, I think. There are a number of factors the Constitution mentioned for the creation of constituencies. And then the Constitution gives the power to the EC to review those constituency boundaries periodically. And there are two conditions that would warrant a review. Now, the first one is that the EC can only review constituency boundaries if the last review was done at least 7 years ago. And then the other condition is that if there has been a census in Ghana and the Statistical Service has published the census results, then based on the new census figures, the EC has to review constituency boundaries. So which of all the two conditions happens earlier? So if the 7-year interval happens earlier than the census results, then the EC can review. And the review doesn't mean it necessarily has to increase the number of constituencies. It can, upon review, decide that it wants to maintain the same number or maybe reduce the number of constituencies or probably create more constituencies or merge some constituencies. So yeah, so those are the two factors. Or if, like I said, the Statistical Service has conducted a census in Ghana, which happens every 10 years, and has published the results, then based on the new population figures, the EC has to review constituency boundaries. Now, I hold a view, and which is also shared by Professor H. Kwesi, that the creation of the Guan constituency would not fall within these requirements. So the conditions for review are different from the circumstances that have warranted or has led us to the need to create a Guan constituency. So if you look at all the things we have recounted from the beginning, the creation of the boundaries, the processes of creating district that was sort of a little bungled up and all that, those factors do not fall within Article 47.5, which is what lays out the requirements for review of constituencies. And that's why we hold the view that in that case, then Article 47.6 would not apply, because Article 47 says that when the EC has reviewed constituency boundaries, that review will not take effect until the next dissolution of Parliament, because the reason is that you would have a Parliament in place, And so if you have reviewed constituency boundaries, we don't want that to take effect immediately to affect the representation, the people that, or the electoral boundaries of the existing members of parliament. So we want that to take effect at the next election, so that the election based on those new boundaries would take effect in the next parliament. So that's the idea. But this particular situation it's a very special one, and it doesn't fall within either of the two requirements that would warrant review of constituencies. So technically, I don't think if a Guan constituency is created, it can be characterized as a review of constituencies, because like the factors that has necessitated the creation of the Guan constituency would not, fall within Article 47.6, because it's neither pursuant to the AC's power to review after a 7-year interval, nor the power to review after a census result has been published. If it doesn't fall in either of those scenarios, so Article 47.6, in my view, would not be applicable in that context. So if a Guan constituency is created eventually in the life of this 8th parliament, my view is that the AC can go ahead and organize the election for the people of Guan to elect a member of parliament to sit in this 8th parliament, and it doesn't have to wait until 2024 for them to be able to vote for a member of parliament.
All right, Prof. I mean, this has been a very exciting and educative program. I've personally learned a lot. I think we are just 3 minutes to 8 o'clock. We spent almost an hour. But before you leave, I want to know your thoughts about the events that happened in Parliament on the election of the Speaker of Parliament. Do you think that constitutionally, are there any, I mean, the question is in two folds. First one, what are your thoughts on the events that happened on the election of the Speaker? And are there any constitutional, more or less like sanctions, legal sanctions that can be meted out by the Privileges Committee or any other person in Parliament?
Yeah, sure. So I think, the events of 7 January were very unfortunate and have dented our democratic credentials to some extent. And so the need to really remedy our image in that regard is important. And I think there are sufficient legal, there are sufficient constitutional and other rules in place to be able to deal with that situation. So you have what is known as the Parliament Act, the Parliament Act 1965, Act 300, which regulates the conduct which regulates various matters in Parliament, including disruptive conduct or disruptive behavior. So when you look at Section 26 of that Act, for instance, it says that an act which impedes or intends to impede Parliament in the performance of its functions or affronts the dignity of Parliament is contempt of Parliament. And then Section 28 says that it is contempt of Parliament for a person to create or join in a disturbance which interrupts or is likely to interrupt the proceedings of Parliament. So all those incidents that happened with people kicking ballot boxes and people stealing ballot papers and running with it and causing commotion here and there would fall within this provision of the Act, of the Parliament Act, which lists instances or the acts that would constitute contempt of Parliament. And so I think there is enough provision in the Act to deal with that situation. And the Act prescribes various sanctions, including exclusion of the member from the proceeding, the particular proceeding in which they engage in disruptive behavior, or they can be reprimanded by the Speaker, or they can be suspended for a period of time in Parliament, or they can be expelled if the House considers that their behavior is very egregious or gross. So all those sanctions are there. And in addition to that, the Parliament Act also says that if you are sanctioned by Parliament in that manner, upon the recommendations of the Privileges Committee, that would not preclude your possible prosecution if what you did also constitutes a criminal offense under the laws of Ghana. So, for instance, you saw that some people were kicking each other and slapping other people in the heat of the moment. Those could constitute assault. And so, in addition to the person who was guilty of that being sanctioned by Parliament by suspension or reprimand, etc., they could possibly also be prosecuted for a criminal offense. And I've heard some people say that, well, members of Parliament have immunity, so what happened in Parliament stays in Parliament, and it cannot be dealt with outside Parliament. I stand. I share a different view. I don't think it's a correct interpretation of the immunity of members of Parliament, because when you look at Article 116, it says that subject to the provisions of this article, but without prejudice to the general effect of Article 115 of this Constitution, civil or criminal proceedings shall not be instituted against a member of Parliament in any court or place outside of Parliament for any matter or thing brought by him or before Parliament by petition, bill, motion, or otherwise. So the immunity of Parliament, the immunity of MPs for things they do in Parliament is in respect of their actual work. When they have brought, let's say, a motion before Parliament, or propose a bill, or propose a resolution, etc., then you cannot prosecute them for it because they are doing their work. And I do not think that what happened in Parliament on that day would fall in any of these categories, either by bringing the matter before Parliament by way of a bill, petition, motion, or otherwise. I mean, so I don't think the immunity of members of Parliament is that is a blanket immunity from any and all possible acts of criminality. So I think that there are enough provisions in the law to be able to deal with that behavior. And I think it will be important for Parliament itself to investigate it, sanction the members who misconducted themselves for their image to be restored.
Prof, thank you very much for such an insight. I just hope that these things which you've listed in the books of the Parliamentary Act are not just statutory provisions stamped in black and white, and we have the balls to actually enforce it when it comes to one of our own, at least to make it a deterrent to the future generation. I mean, if indeed we really want to do it, then this is the right time to do it. So it becomes something that we can look on. We spent 1 hour. I don't know whether if any one of us has any question, please unmute yourself and ask Chris. I know this is quite a technical one, but personally I've enjoyed it. I really, in terms of the chronology of how the SAL and then the Guan constituency, the constitutional implication. So if you have any contribution or question, please unmute yourself and ask.
Hello, Chris.
Hello.
Yeah, I wanted to find out. Oh, I'm not a law person, but I wanted to find out where, our parliament, they have about 275 parliamentarians. So in the case of Guan, where let's say EC grants the permission for them to have an MP and they vote, and let's say now it's going to become like 276. And with the 276, there can be a possibility where we have 138, 138. So in this case, how do you?
Yeah, so what the Constitution says is that, contrary to what you may think, the Constitution does not prescribe that the total membership of Parliament should be an odd number. That's not what it doesn't say that. So you can have the membership of Parliament being an even number, and we've had that in the past. Actually, I think until 2004, when the number of constituencies, the EC reviewed the constituency boundaries, we had 200 members of Parliament at the time. So we've had a situation in our past where we had an odd number, 200. So it won't be a new thing to have 276, which will be, an even number. We won't have a different situation or a new situation when we have 276. But what the Constitution says is that if you have an even number in such a situation, and then there is a motion in Parliament and there's a split vote, equal numbers on both sides of the motion. Let's say a minister is proposed for approval, and you have Guan joining later on, and then there's 136 on this side for the minister to be approved and 138 on that side for the minister not to be approved. What the Constitution says is that if there's a split vote or equal vote on a particular motion, that motion is considered as lost. So it means that equal number of votes equals a negative vote by what our Constitution provides. So yeah, so it's very important. So the Guan, if a Guan MP is elected eventually, it would shift the balance of power in Parliament, depending on which party wins it anyway. So yeah, but so depending on where, yeah.
So Chris, in this case, like assuming, let's say he was elected before the selection of the speaker, and it was like 138. So who then becomes the Speaker of Parliament?
It means that there's no speaker. So then it means that there has to be another way. So there has to be, they have to conduct an election until there's a majority.
Wow.
Yes.
So there's nothing like maybe another article or something that says when it's like that, maybe we go by this way. There's nothing like that.
Not as far as I know, but I mean, so that's why, you see, Parliament is a deliberative body, right? So they engage in negotiations, talk to either side, and in most cases they arrive by they build consensus and take decisions by consensus. It's only in a few instances that matters become contentious and they have to take a vote, etc. So if there's a deadlock, I mean, they can always negotiate, give and take, just like it happened on 7th December. I mean, when things became heated, you realize that the leadership went into a caucus meeting, or what they called, has been described in the media as a conclave, to borrow a term from the Vatican. So they go have discussions, and then they try to, make compromises, and then take a decision that serves the interests of both sides. So yeah, so that's how it's supposed to be, and it's not, it wouldn't be only Ghana. If you look at the U.S. Senate too, it has 100 members. But what is different in the U.S. Senate system is that the vice president is the president of the Senate. So when there's an equal number of votes or there's a tie, the vice president has a casting vote. In our system, the speaker has no casting vote. The speaker is just an umpire to preside over affairs and direct the discussions and put a question for the members to vote. So if there is an equal number of votes, the motion is lost, and they could probably, that motion could be relayed, and then maybe they could try and build consensus, give and take, or amend it to satisfy the interests of those who voted against it, so that the national interest can be served. I mean, it wouldn't be a totally negative thing. I think it could be a positive thing, because it would show, especially to those in government, that they need to build consensus and kind of push through whatever policies they want, even if there is strong opposition to it.
Okay, thank you.
Yes.
Richie, thank you for.
Are there any other questions? I see some. Is it in the chat or something?
Yeah, so a chat. Aaron Opokuwa says, "Thank you very much, Doc. Learned a lot." And then Ben Chum also says, "Same here. Most grateful," said Doc Chris. So, Professor, thank you very much for your time. I know it's morning in Sydney. It's 6 a.m. or 7 a.m., right?
Melbourne, actually. It's it's 7 a.m.
My regards to Carbolic Snowball guy. What's his name? The Carbolic Snowball. All right, sir. Thank you very much. We are grateful. We are extremely grateful for your time and insights, and we hope to call on you very soon for another very exciting episode on the Lawyer's Diary. So thank you very much. Thank you.
All right, my regards to everybody, and thank you for having me.
All right, thanks. Bye.
All right, bye.